if you are new to the Cromeens law firm, we are a full service construction law firm based in Houston, Texas. We also have locations in San Antonio and Austin, and we have any number of services throughout the country as well. So we are really glad you guys are here with us this morning. I'm going to go ahead and pass this over to Karalynn so we can go ahead and get this presentation started. Give me one moment. I'm just going to make sure, scroll through, make sure that we've got all of our video sharing and audio sharing closed off here. Alrighty, and without any further ado, I'm going to pass this over to Karalynn. Take it away, Karalynn.
Thank you, Miss Chelsea. Thank you all for being here. Like Chelsea said, we have certain things. Where'd the screen go, Chelsea? Got it. We have contracts and liens in all 50 states. Today, we're going to dive into what are some of the main parts of a residential contract. And this is specifically for residential contractors when you're dealing with the homeowner, what should be in there. If you have questions about commercial subcontracts, Chelsea can send you the video to a webinar we did yesterday about some terms to watch out for that. Chelsea's also going to put her email in the chat. So if you wanted to schedule a consultation with me to talk specifically about your contracts, we do offer a flat fee residential repair remodel contract for $1,750. So if you wanted us to draft it for you, that would be the price. And how that works is you call and we'll have a little consult and we'll go over what's important to you. And then we kind of go from there and draft it specifically for your type of work and in your state. Because every state has a little bit something different for what's required to be in a residential contract on top of the things that we're going to go over. But even if you can't do that at this point, if you have something, even if it's handwritten or typed or an email that has the things that we're going to go over today, that is a great start on having a contract and something in writing. So let's dive right in. Like Chelsea said, we'll do questions at the end, so just have them ready. All right, so what is the risk of not having a contract? Man, we're gonna get into some stories here shortly about some actual what happened when we didn't have a contract, but the main purpose of a contract is managing expectations, right? And if we don't have that, we can't do that properly. And here's where I relate it to, right? Is that the homeowner has in their mind something of how the project is going to go, and they have this certain idea of how things are going to happen, and it's not based on anything in the construction reality, right? It's just based on what they heard their brother-in-law or their sister-in-law or somebody, their friend at work say this is what happened to them, but it's not really based on what really happens. And so if we don't clear up those communications, that's the status that we're going to be judged against, and sometimes it's unrealistic. And I can say, having for the last 17 years represented both homeowners and contractors in litigation, one of the biggest things that happens is just a miscommunication. Nobody knew what they were supposed to do. And I really believe if we can drill down on that in the very beginning of the relationship, a lot less likely to get sued and end up where you need an attorney. So that is kind of the importance before you begin working, that we have a contract in writing. So an example of a risk that I've dealt with personally is I had a door contractor that was hired by a homeowner, and this homeowner fell in love with these certain doors. She just loved them, and she wanted them on the outside of her house, and they were interior doors. And he told her, you can't put these on the outside. They're not meant for that. They're interior doors. Well, she demanded that he did. He never got anything in writing and saying that, but he installed the doors on the exterior. And of course, like he said, within 6 months or a year, these doors are falling apart because, especially in Texas, exterior doors have to be a heavier grade than interior. So she ended up suing him, and he ended up losing because he didn't have anything that said, yes, I agree that I know that these are interior doors and I'm putting on the outside and I'll take all the risk. So, things, especially no handshake deals or something, especially something like that, make sure we get it in writing, because you never know what's going to happen. And the sooner we can be upfront about it, the better off we are. So, next slide, Chelsea. Okay. No matter how small the project is, we need something in writing, even if it's just a small invoice explaining what you're going to do. And guys, true, honestly, even when you do somebody a favor and you're like, oh, it's just a favor I'm doing for my church or for, a friend down the street, I would just put it in, even if the balance is zero at the bottom, you're going to say exactly what you're going to do. You have no idea how many people I've had in here that are being sued when they didn't even get paid because they were doing somebody a favor, or they're giving somebody a deal, they did the extra work, they didn't put it in writing, and then that extra part of work that we weren't happy with, and that's what they got sued over. So another thing here too is you have your processes, you have the things that you normally do. Trust your gut on going outside of those things, and let's be real detailed about what that looks like. So getting back to doing people favors, I once represented this roofing contractor who had a client that had a commercial building, and he did the roof on the commercial building, and the guy's like, hey, can you do my roof at home? And he's like, yeah. And he's like, actually I can do it for a discount because I have all of these expired shingles that don't have that don't match, they're discontinued, they don't make them anymore, but I don't have enough to do a full roof, so I'll there'll be different colors, but I'll do them on your roof. And so he, yeah, that sounds great, give me the discount, I'll take the discolored shingles. We don't have anything in writing. He does the house, and it's like blue shingles, brown shingles, all kinds of different shingles. And of course, the owner throws a fit and said, this is not what I agreed to. And so my client gets sued and now has to reshingle the whole roof for free because he didn't have anything in writing saying, hey, I'm doing you a favor. We're going to use these discontinued shingles, and yeah, and plus pay me an attorney to defend him and to work through this and tell him, yeah, it's a verbal. And if I go into a courtroom and tell a jury, hey, yeah, I agreed to all these different kind of shingles, they're probably not going to believe it. So again, make sure that everything is in writing, even the smallest jobs. And because here's the thing, is if you don't have an agreement, somebody else, if you get into a dispute, is going to decide what the agreement was. So that's either going to be a judge if it's a bench trial, or a jury, which is 12 people, 6 to 12 people, depending on what court you're in, that's going to hear all the evidence and determine what your agreement was. But you have to understand that these aren't people that are familiar with construction, anything like that, or when a juror from personal experience sees punch list items, they're like, oh my God, I can't believe such horrible work. I can't believe you left the project like that, because they don't understand the process. And the other thing is that a lot of what they're basing their decision on is your credibility and how you look. They're judging your appearance. They're judging, how you talk. It's not on what the agreement actually was. You're bringing it down to a bunch of people, to a bunch of strangers, to the transaction to make the decision about what the agreement was. And when there's nothing in writing, either party can say what they thought it was, and whether it's true or not, we don't know, right? So that's why, first off, it's expensive to get to a jury trial anyways, but then to have somebody deciding who doesn't understand construction or how all this works, I've seen it can be very hurtful. So another reason why to have, can you go to the next slide, Chelsea? Something in writing to protect yourself, protect your company. And here's the thing too, guys, is that if we get to a point where we get sued, not only have the stress of dealing with that litigation, then you're going to have to spend time with me going to depositions, producing documents that don't even deal with this case or this issue. You could have to produce those, going through all of your emails, all of your text messages. It's just really a pain in the ass, right? And if you're being sued, the best you can hope is not to pay more. There's really no benefit to it. So I'm hitting this hard, and I hope that you never have to experience this, but I'm doing that because I don't want you to have to experience it. So let's have something in writing, even if it's on an invoice, something really simple. Something is better than nothing. And so I mentioned briefly before, going outside what you normally do. And if you do, let's document it very clearly, right? Because what does that look like? So I have a client that builds homes for a living, and he decided that an owner asked him to be a construction manager. He's not going to build it. He's going to write all the checks. He's just going to manage the trades that are there. And so he didn't have him sign a contract because he's a home builder. Normally he builds from the ground up. He didn't think he needed one. This is just a, I'm just managing the project. Well, towards the end of the project, the owner, my guy originally hired the roofing contractor on behalf of the owner. And apparently things went south between the roofing contractor and the owner. But the contract with the roofing contractor was signed by my client. And so the roofing contractor had to sue my client because that's who the agreement was with. My client didn't, have the money, didn't manage that part of the job, but now he's the one who got sued, right? And now he's got to defend himself. His wife was not very happy about it either because they're a small business, right? And as opposed to if we would have taken the time to kind of modify his current contract and say, hey, this is what we're doing, that we're just a construction manager. When he got sued or when he got that demand letter, we could have been like, oh, here's the contract that shows you. That's not what we were hired to do. We were just managing. So you really need to sue the owner. So yes, you can go outside what you normally do, but let's document it well. And that way there's no misunderstanding of what you're hired to do or what it looks like. So another example of why it's important. All right, the function of your contract. Like I said, the function of your contract is to manage expectations. And number one, it does not have to be full of legalese to be effective, right? You can just talk in plain English, like here's the scope of the work, or, very plain English. There's no magic terms that need to be in there to protect you. And actually, the easier it is to understand, the easier it is to understand if you get into a dispute. So what I really try to do in the contracts I write for residential repair remodels are and something that you can understand and your customer can understand. And so we can really manage expectations because we know what's involved. It's in very plain English. So, and each party knowing what they're responsible for, right? Because that's a huge part. And we'll dive in a little bit more into the specific areas here in a second. Like I said, the homeowner has an idea of how things should go. If you don't correct that picture that's in their head, that's the standard you're going to be judged against, and you don't know what they're thinking. And I can promise you they're not thinking anything realistic. So let's be real about what's involved and just lay it on out there and, just be honest about it. So here's some of the main things, like if you're going to write your own contract that I would have in a contract. So if you're just doing, just starting out and you want to have the best contract you can write, these are the things that I would put in there. And what you could do is you could get a Word doc and just, label it the scope of work and the project schedule. And then we'll go into how we're going to describe that here in a second. But main thing is just being upfront, have it signed before you start the work. All right, so scope of work, which is the next one. Okay, a clear description of the work. If there's drawings, you can reference those drawings in the scope of work. Put in there what's not included. Some language that can be added specifically. If it's not listed above, it's not included in my scope of work. Or, if you've been in your business long enough and you've had homeowners think that something that they think should be included is not. The clearer what I tell my clients is pretend you were describing your scope of work to 12 people who know nothing about construction. That would be a jury you might end up describing it to. So you have to be clear and just be upfront, especially you're coming into somebody's home. It's their most private area. It's the thing they, take to heart. It's where they come to rest. So they need to know what this is going to look like before you even get started. Project schedule. This is the same on any type of project, whether it's commercial or residential. More than anything, when somebody starts a construction project, they want to know when it's going to be done. Especially if somebody's in your house and you're like doing a patio, or they want to know when they can have a party. They want to know when they can have people over to enjoy what you've done and to show it off. And so what I always tell my clients is go long. Give yourself 2 extra weeks, because if you finish early, you're a hero. If you finish late, you're a zero. So really just give yourself plenty of time. And I go into this in change orders too. But if there's anything that could possibly push out your scheduled completion date that is beyond your control, tell them up front. You'll really seem professional and you know what you're doing if you're like, hey, I'm giving you this schedule, but it's based on me being able to get to the lumber. I need to build this. If I can't, I'll let you know, and here's where we're going to go from there. But not mentioning it and then it happens, that's like oh my God, how could they have not known that this is going to happen? And it really shakes the homeowner's core of like, did I hire the right person? Do they really know what they're doing? So, you know, as being honest and upfront as possible, that's such a big part of it. So another thing that got it, managing expectation is change orders, right? What happens if we come across a situation that would cost more money, right? So have a process written in here. If this happens, we're going to have a discussion. I'm going to give you some options, and then we're going to write up a change order form. If you need, I have free change order forms at subcontractorinstitute.com, or you can do your own, just the work and the price, and have them sign off it. And I also put in your contract that change orders are due upon completion or the next milestone, so that we know when they're supposed to be paid, and things like that. So make sure that we have a provision for change orders in the contract. So the other thing, telling the homeowner that a change order might be possible. And I put this in my contracts, like for my repair remodel guys, and especially my roofers, is that I am really good at what I do. I'm a professional, but I don't have x-ray vision, and so I can't see through the walls and see what I'm going to do, what I'm going to get into when I tear into those things. Is there going to be extra work? I don't know what kind of sheathing might need to be replaced that's under those shingles. And so if that happens, it's going to cost more, but we're going to have a discussion before I do that extra work. What does that look like? What are the potential, you know, you can talk to them about the potential price ranges of what that must cost. What it gives you is like, oh my gosh, he told me this could happen. It happened. Okay, I understand. As opposed to, you don't tell them it's going to happen. All of a sudden you tell them you need several more $100s to finish their roof because all of the sheathing is rotted. It's a huge shock to them. And like I said, again, they are judging you against the standard of something that is unrealistic. And if we don't clear that up, like, this is obviously a possibility. It seems obvious to us, right? Like, obviously I can't see through your walls and know what's on the other side of that. It's not to them. It's not. And it's just, when we come to doing constructions in somebody's home that has no background in construction, we're really speaking two different languages. And what a contract does is put us on the same page. It's so essential. So change orders. All right, another thing that I know residential contractors in general are not very good at. Can you go to the next slide, Chelsea? Our payment terms, right? So let's be upfront about what those payment terms are. And the other thing is if you're more than a couple days and you have a milestone payment schedule, what I like to tell my clients to do is invoice when you reach that milestone, because it may be very obvious to you that you've reached that milestone, but it's not to your homeowner. They kind of think maybe, yeah, it kind of looks like it, but I'm not sure. They'll let me know. So what I put in my contracts is when we get to this milestone, we're going to send you an invoice, then you have 5 days to pay it, right? And then what happens if you don't pay in 5 days? We'll get to that in a second, but whatever, if there's a down payment required, make sure that's clear, and then when the next steps are. And the other thing too, as a contractor, I try to make as much paid towards the front of the job, so when we get to the end, there's a very little left. So if there is some kind of dispute, that we're talking about a small amount of money, not a huge amount. So I do front end the contracts. That's what I suggest, depending on the rules of your state. But we can get into, every state requires something specifically, except for California. You definitely cannot get anything over $1,000 there, and you cannot bill in advance. So I mean, be paid in advance. So we got to watch the rules in that state. All right, so what to do when someone drops a ball or we don't have a contract provision that covers us. So this is what I call a default section. Okay, so a default under a contract just means somebody's not doing what they're supposed to be doing. And most generally on the owner side is somebody's not paying when they're supposed to, right? And so what we could say in this default section is, it says, owner, I issued you an invoice, you have 5 days to pay. If you don't, you're in default. I can give you another 3 days, and then I can decide if I want to terminate the contract or whatever that looks like. But this section, and the same thing with the homeowner. If the homeowner thinks you're not doing what you're supposed to, they can give you a notice of default. You got a cure, or they have the right to terminate. What I kind of do in this section too is I usually leave my contractors an any way out, just in case they don't like the homeowner or something, not saying that they have to use it, basically that I, the contractor, can decide to end this relationship at any time, and we'll basically even up the account. If I owe you anything, I'll pay you, whatever that is. Just because you never know what kind of situation that you run into. I usually don't give that same kind of out to the owners, so that means they're tied in. So default section is also hugely important. Okay, and so this is, you're given a written notice of default, you have a time to cure it. If not, you can terminate. Okay, so termination works both ways. You, the contractor, can terminate the homeowner if they don't pay, or if not, things are not going as well. You could also get terminated as the contractor, right? If the homeowner thinks you're in default or doesn't like what you're doing. The main thing I want to point out in termination is that if you, the contractor, get terminated, you risk more than just not getting paid for the work that you did, right? It could happen, I'm not saying it will 100% of the time, but it could happen that the homeowner goes and pays and finishes your scope of work, right? And it costs them more than what you said you would do the work for, and you're on the hook for that difference. If they hired a replacement contractor to finish your work, if you got terminated, and it cost them $30,000 more to finish that work, then they could sue you for that $30,000. Because basically you made a promise to do that work for a certain price, and when you didn't, you broke that promise, and now you're responsible for the difference. So I do like to bring that up so people realize it's not just walking away from the project that you have to worry about. There could be more issues involved. So just know that. And right now, especially protecting against uncontrollable circumstances, we're going to get into, I think, is hugely important. So the next slide. Okay, so labor shortage and material shortages and material increased price cost. We're talking about putting in the contract here. I also think it's a good idea if you do bids that you put these things in your bid, or make your bid good for 10 or 15 days, and then you can increase the price, just because it's so volatile out there right now with materials and the price of materials and the availability of materials. So you can add something like this exact language in here to your contract, is that if, and you can change the percentage to be whatever you want. If the materials increase more than 2 or 3% from the estimated cost of this project, contractor is entitled to be paid the difference. Because here's the thing, if you don't have that provision in there, you cannot get the difference. Basically, like I said, you promised to do this work for this price, regardless of what it actually cost you. So when you sign that contract, that's what you're saying. I'm gonna do this work for this price, and unless we have something like this built in, that's the price, right? But if we have something like this built in and it costs us more, we'll be like, hey, here's what I bid it for, here's what it actually is. Under my contract, I'm entitled to get this cost, so I'm just gonna add it to the next milestone payment, or pay up, whatever the next step is. So I would put this in your bid too. Another thing, this is for labor shortages, you could also put in here for material shortages. If you're unable to complete the work, or you have to put the schedule down, it's an excused, it's basically excused default. And so if this happens, like you can't get materials in time, and you have a schedule in your contract, you can do a change order, or you can just send them an email saying, hey, I know I said this date, but I told you material shortage could be an issue, so now we're looking at this as the completion date. As long as we have something in writing updating that completion date and just letting them know, if we have a provision like this, then we'd be covered, and we wouldn't have to, because if not, the schedule you give in your contract is what you're going to be held to. So this gives you some wiggle room. If something like that happens, it would give you more time. So make sure we're putting that all the bids. Like I said, if you don't have those things in there, like extend the time for labor shortage or material shortages or increase price, then you won't be able to get more time or increase your price because it's not in your contract. So, and then you could be sued for breach of contract if you don't finish. Like I said, so those are the main points, the main things. Like if you were going to handwrite a contract, that I would have in there. A handwritten contract, an email contract is better than no contract at all. But guys, I do think if you're at a point in your business where you can afford the $1,750, $1,750 to do the contract, I think it's well worth the investment. We have a 5 business day turnaround. It's really something, it's designed to help you, and you can, and obviously you can use it over and over and over again, and then we're here if you ever need to tweak it or anything like that. So we're here for all the things. Anybody have questions?
Looks like we've got some
Gotcha.
questions here in the chat.
Perfect.
Chat asks, how long are your typical single phase contracts? Something like a screen porch. I just need something simple, but the tab contract package short form is 15 pages long.
Yeah. No, mine are usually 10. With something like that, it's going to take multiple days. I would go ahead and do the 10-page contract. But here's the thing, like in my contract, like I said, it's in plain English. If you're in and out in a day, I would say you could just do an invoice with terms and conditions. But something that's going to be longer than a couple days, I think we need more of a contract. And plus, when you go in and be like, hey, if you have any questions, I can explain this to you, or we can go over it. It's because it's in plain English. So I think it's worth it.
Awesome. We've got a question from Jorge asking, what are acceptable payment terms? Can you provide some examples? What is not appropriate?
Okay, so pretty much, unless you're in California, you can write your own payment terms, right? So 10% down, milestones, 10 and then 25, and then we'll leave the smallest percentage for last. It really depends on how long the project is. Or if you're there and in and out in one day, a deposit before you start and then check upon completion. It's really up to you, and you need to look at the cash flow of your business and what that looks like, and the length of your project. If there's, we can have a conversation about specific for your business, what that looks like. But obviously, getting paid relatively quickly if it's a quick project.
Great. We've got a question here from Franklin. Can you make the contract specific to each state?
Absolutely, and we have the language required that. Yes, so for each state has a little something different. Like California basically writes a residential contract for you. Texas, we have a little something we have to add, but every state's got a little something that needs to be added to a residential contract, just because every state likes to have a little more protection for a homeowner, just because usually they're not a savvy commercial person, so they like to have language in there, and especially if you were talking about lien rights, you have to let the homeowner know in most states that a lien could be filed in the contract. So yeah, we can do it for all 50 states.
Great. We've got quite a few questions still rolling in here. We've got one from Elizabeth. Are there any special considerations for projects involving two homeowners, i.e. two next door neighbors that need to demolish and rebuild a shared driveway/garage?
Man, if it's shared and we're doing this together, I need all of them to sign off on the contract. I wouldn't, they all gotta, the main thing that I would be worried about is you getting caught in a dispute between those two. So they got to be clear on what they're hiring you for, and then they all sign the contract and we all agree that, and then who gives direction, right? We got to decide in the contract, like if this person says this, who am I taking direction for? Because I only want to take direction from one person. So I would spell that out too. Like, you owners have to designate a representative, and that's who I'm dealing with, because I can't imagine having the same conversation 4 times in a row. And you can do like, this is my representative, but we'll have, weekly meetings at this time and date where we'll answer any questions you have. But that way we're only dealing with one person. And also too, it clears up things like if you were going to get a legal dispute, I was only instructed to listen to this person. Anything else outside of that, I'm not responsible for. So those would be the 2 main things that I would make sure to have in there when we're dealing with something like that.
That's great. That's super helpful. Another question from Chad. Is it a legal requirement for clients to have to sign each page of a contract, or can I attach it to their approved proposal and have them electronically sign the last page?
Yeah, they don't have to sign the bottom of each page. Sometimes, if you have a special provision that you really want them to pay attention to, like, hey, if you cancel after 4 days, it's still going to cost you 10% of the deposit. I would probably have them initial that just to bring their attention to it, but it's not required. But no, as long as we can prove, like, even if we don't have electronic signature works great. And even if you get into the point where you're going back and forth on the emails, you can say, here's the contract, do you approve the terms? And they email back yes, that would still be good enough. Because, and just so you guys know, in a situation where, say we send over a contract, it just gets busy, it doesn't get signed. If we start acting like we're under that contract, the law is going to say that we're under that contract, and then the signature is just a formality. So the main thing is we got to have something in an e-signature works great to say that, yes, I did actually approve of those terms.
Good stuff. Awesome. Alrighty. Do we have any other questions before we go ahead and call it a day? Anybody else have anything that they'd like to ask Karalynn? You're more than welcome to send it in the chat or unmute yourselves and ask as well. Awesome. We've got another one in here really quickly from Chad. Do I, as a remodeler, need to provide a list of subcontractors to each client prior to starting a project, or do I need to have them sign a waiver concerning such?
It depends on your state. I'd have to look at the rules of your state to be able to tell for sure. I know in Texas you don't, but besides that, I'd have to go back and look at the rules for each state. Texas
Chad
does
says Texas.
okay, so Texas does have a thing that says you can provide it, but it's not required. There's a voluntary section in there, but yeah, you don't have to. And you don't have to get them to sign a waiver either. You are required to, at the end of a residential project, if the owner requests, give them a unconditional lien waiver, basically saying, or all bills paid affidavit too, saying that you've paid everyone. So that way they can rely on that. Oh, thanks.
Awesome. And then I believe, let's see here, we've got one from Jorge. He asked about the door guy that I believe one of the individuals you referenced earlier in this presentation. He asked, how was he sued? Was it small claims?
No, it was too big of a claim. It was actually in county court. And we ended up paying, he had to pay him, and then I finally convinced him, like, you're going to pay me $40,000 to go to trial, and you're probably going to lose because I don't have anything in writing. So let's pay them something. And he had to pay me attorney's fees too. So that, like if we're under a contract, that would have been a change order that had to be clearly in writing. An arbitration clause.
Yes. Yep.
Yeah.
I was about to say.
Yeah, I see it. An arbitration clause. What is an arbitration clause? So an arbitration, so basically, if we don't have an arbitration clause, what happens is you go in front of a judge, in front of a court, right? A district court or a county court, depending on your state, or they call it different things, and it's the public court system. If you have an arbitration clause, that is a private, and most of them are done through the AAA, and it's done privately. So basically what happens is there is arbitrators, or like I could be an arbitrator. So once you file an arbitration, the American Arbitration Association sends you like 15 resumes of possible arbitrators, and you on the other side go through and check out the ones you want, and then they get that list back, and then you're appointed an arbitrator, who is normally an individual that's versed in construction. It doesn't have to be an attorney, but it can be, but somebody that's familiar with the construction industry. And then you go to trial in front of that arbitrator. So basically, you will have a final judgment after you go to arbitration. The good thing about arbitration is it's fast, and it's done by somebody who's familiar with construction. The bad thing about arbitration is it costs more up front. So where you were to file a lawsuit in the public court system, it's a couple $100. If you file an arbitration, depending on the amount of your claim, it's $2,000 to $3,000. But the thing that I can tell you is that because arbitration is so efficient, we don't spend years in the courtroom, and we save a lot of time on attorney's fees that actually you save so much just by paying for the arbitration fee up front. Okay, on the follow-up on the shared garage situation, how would you handle payments? Should be identified representative. Only, yeah, I would have them agree on that. Who the same thing, if they're gonna give you a representative that they deal with, and it might be the same person. That representative is the one you go to for payment, and that representative can approve payments. Just because, just be careful with that one. And don't be wrong, you could file a lien on the property either way if you're not paid. So I'm not so worried about that situation. It's just the administrative deal of dealing. Who do I deal with? Who's going to write me a check? Who do I need to call for that? So I would just be upfront about that part of it.
Awesome. All righty, well, we're going to go ahead and call it here, everyone. We will be reaching out shortly after this with a copy of the presentation, with Karalynn's contact information. And in reaching out, you'll also have access to my email address if you're interested in setting up a consultation. We can get that started. Thank you all for joining us today. We're so glad that you could come attend this webinar, get some good information, and we hope that we can speak with you all again soon. Have a great day,
Absolutely. Thank
everyone.
you. Hey, and hey, if you want some more, we're going to send out this presentation, but also this month's blogs articles kind of dives in deep in this situation too, and that's available on the website.
Yeah,
Have a great
absolutely.
day,
I'll make sure to link
everyone.
those.
Yeah, that'd be
Bye,
great. Thank you,
everyone.
Kelsey.
No worries.